She says she won't come out of the holding cell. Well, that won't last very long.
No, she will. She wants to come out.
Okay. Well, if she'll come out, I mean, I'm glad to hear it. It's important. All right, then we will go to Ms. Celestine's case. We will let the state be able to set up. There's very important issues today. Now we were on this, well, just set the case up a minute. It's back to me.
All right. 23B 1593 etched in.
Okay. All right. Ms. Celestine, actually, as I told her earlier today, I had various important legal issues to take up. She was disruptive. After repeated warnings, she was removed from the courtroom. The next important issue, and if Ms. Celestine would quit trying to represent herself, she would have seen this. There was a bench warrant issued for her arrest. She appeared in court on that bench warrant. Therefore, the bench warrant was resolved. Her prior examination by the record indicates that her prior bond had a judgment forfeiture, which was cured. The sheriff levied, it was satisfied, the bond was never set aside. So if she would have spent more time on paying attention to the legal principles that actually apply, other than this nonsense gibberish, she would have realized it. But she didn't. So now the state has filed a motion to revoke the bond.
Yeah.
And that's the important matter we're on today. So, and she's entitled to notice and due process. So that's why she was brought over today, because those matters are expedited. So let me hear from the state on the state's motion to revoke bond.
And Your Honor, some of the facts you've already put in the record. I will say that on June 21st, 2023 is when the defendant failed to appear in Calengar. The bench warrant was issued. Subsequently, October 20th, 2023, a bond forfeiture was granted. We would submit to the court that basically for 2 years, the defendant evaded the bench warrant. And it looks like September 16th, 2025, the defendant was arrested by Georgia State Patrol. And that was for new offenses of obstruction, distracted driving, suspended license, and improper use of intent. The state arrest meeting, that was September 16th, 2025.
Right, so after the time she failed to appear in the court, did she have any other arrests other than this driving?
Not that I'm aware of. And so it wasn't until this arrest by Georgia State Patrol that they discovered the bench warrant was outstanding. So we would submit to the court that based on the defendant's own statements in court and her filings, she does not recognize this court's authority. She does not believe this court has any personal jurisdiction over her. And we would submit that any bond condition she would just ignore, and she does pose a flight risk. Secondly, we would submit to the court that when she was arrested, she basically committed several offenses, which she was out on bond for, with the exception of the fleeing and attempting to elude and the possession of the marijuana. The remaining counts are virtually identical to the counts that she was arrested for: distracted driving. No license, no license plate, obstruction of police. And so we would argue that she violated the conditions of her bond, and she does pose a danger to the community.
Okay. Is she out on probation or parole on any prior offense?
I don't believe so.
And when she was arrested, did she give a new address?
No, I believe she gave the same address as the arrest.
Which was what?
Yep.
Thanks.
The address I'm showing is 2214 Upper Falls Avenue, Latham.
Falls.
Yes. POPLAR. And the zip code is 30058.
Okay. Now, Ms. Celestine, that is, the issue before me is revoking or modifying your bond. If you will, I'll give you an opportunity to be heard in the courtroom if you will come in and get to the point of that. If you keep giving me those nonsense legal claims, and I've been hearing those for 40 years, man. They're nonsense. They're right up there with the Easter Bunny. I don't mean to insult the Easter Bunny. So you want to come out, I'm glad to hear for you. It's an important legal issue. But if you would have quit trying to represent yourself, you would have recognized that you could have posted bond, reposted bond. But you're more concerned with the nonsense than really what applies. And that is to your detriment. But you have a right to make bad decisions. Thus far, you've exercised them. All right, let's see if she wants to come out and be heard on the issue of revoking her bond. If she complies and she does what she's supposed to, I'm glad to hear her out. If she becomes once again disruptive, she will be removed.
Judge, she said that she would like to come out, so I will bring her to you in person.
Okay, so she said she won't come out of the holding cell. Well, that won't last very long.
No, she will. She wants to come out.
Okay, well, if she'll come out, I'm glad to hear it. It's important.
Yes, sir.
So let's see whether or not she will comply, Tony.
Yeah.
All right, Celestine is with us. Ma'am, the issue is revoking your bond. State is contending that your bond should be revoked. You don't agree with any authorities to court, and you've been missing for 2 years. So, I'm glad to hear from you concerning what you want to tell me. Now, typically bond is based on whether you're a flight risk. So that's a big hurdle. Been gone. The second one is whether you're a threat or danger to the community. The third is whether or not you're a risk of committing future felony offenses. I've not heard that since you originally posted bond that she had any felony arrests. Is that correct?
Correct.
It's likely that you would pass that criteria. I gotta make all 4. Now, the last one is whether or not you would intimidate witnesses or obstruct justice. I think all the witnesses in this case are wrong.
Yes.
So the likelihood of your intimidating them is just about 0. So the main issues for my reconsideration of your bond is number 1, you're a flight risk. Number 2, whether or not you're a threat or danger to any person in the community. I find that you qualify to the other 2 factors. So what would you like to tell me, if anything, concerning whether or not you should be, once again, you should leave your bond where it is right now. Which I think was, what was it, 20-some thousand, 30,000. Or I should just strike it. So I'm ready to hear from you if you will get to the lawful point.
Right, I would like to make my statements without interruptions, because if I don't have the right to be heard, then we might as well just.
And you have a right to be heard on those issues, because that's the matter
Right.
right now.
Okay.
If you
so
don't
that-
want to talk about those issues, then that concludes this part of the hearing. The other part I've got that I still haven't been able to get through is your Feretta hearing. They're not gift counsel. You've already missed a huge legal issue on the ability to post bond and what a bench warrant does after you appear in court. So you're not doing well on your own.
Well,
Do you wish to respond to the bond criteria or not?
well, first, the bond is excessive, and I'm not supposed to have be compelled to pay any costs until a conviction on a final trial. So that is my 17th guaranteed protection under the Article 1, Section 1, paragraph 17 of the Constitution for Georgia. And Article 9 of the Constitution for the United States, which you have an oath to, states that y'all are not supposed to deny or disparage any of my inherent rights that are reserved to me. I have reserved all human rights, natural rights, consanguinity rights, birth rights, constitutional protected rights, and treaty protected rights. And they have been denied and disparaged as if they don't exist. Those are my retaining rights. So I'm trying to understand, what are we doing? What am I supposed to do? What is my way out? What? I'm constantly feeling like you guys are usurping my rights. I don't even know who this man is, and he's bearing false witness against me. He's got a story that he has just finagled out of anywhere. I don't even know the people on this whole case. I don't know anybody, but I'm sitting here being again accused under and not presumed innocent. I'm sitting in chains in a inhumane living conditions. I've never experienced this. I don't have a record. This type of thing is for someone who is actually somebody who is a criminal. I'm not a criminal. I am innocent. And I keep trying to tell you guys my status and my rights.
I have given you your time for a little bit of your talking about the issues that don't apply to bond. Now we're back on.
I did give you Article.
The two bond conditions, yes or no?
I gave you Article 1, Section 1, paragraph 17. I'm not to be compelled to pay any bond, anything, until conviction on a final trial. And I should,
Well, you know,
Amendment 8, I should not be held under false imprisonment,
okay.
under cruel and unusual punishment, under any bail. That's the Constitution. And is that not correct, sir?
No, you aren't. Just something else you're wrong about. But anyway, ma'am, I'm once again sad.
I can adjust
that you
this comments
no,
and opinions be posted on the record.
This is where I'll have you removed, because right
You
now,
might as
you're
well.
clearly not gonna respond to that based on the arguments before me and the non-response by the defendant. I find that the state has met their burden to revoke bond. So I guess in part, you're having it granted, you won't have to pay anything, because you're not gonna have anything to pay.
That's fine.
So take care, ma'am. All right, take care. All right.